Hi everyone, I'm Frank LoMonte. I'm a professor at the University of Florida, Gainesville, coming to you from the Breckner Center for Freedom of Information, where I'm the director. I teach media law, and prior to taking on this position in 2017, I spent almost 10 years as the national director at the nonprofit Student Press Law Center, which is online at splc.org. Wonderful resource for you, has free legal help for student journalists and for the educators that advise them. And in that capacity, I took a few thousand phone calls to our legal hotline from people around the country who were experiencing legal questions about their right to gather and publish news. So what I wanted to talk to you about today is kind of drawn from that experience of fielding those questions from student journalists and journalism educators, because after you do that for a while, they tend to cluster around certain patterns. You see some familiar themes emerge. And when I thought about what somebody teaching multimedia journalism could most usefully take away from a lesson about the law, I thought, well, we should talk a little bit about the law of gathering information, and then a little bit about the law of publishing information. And I hope to leave you with some practical tips about each of those areas of the law. So let's start by talking about the law of gathering information, right? The Supreme Court has told us over and over again that once you have your hands on information, once you actually have possession of news, there is almost nothing that the government can do to stop you. That's called a prior restraint, and in 150 years of litigating, the Supreme Court has never approved a prior restraint on journalists. So once a journalist has their hands on information, nothing the government can do to stop you from distributing it. That's clear. What is surprisingly less clear is your First Amendment right to be where news is happening in the first place. You would think after a century and a half of litigating we would know the answer to this, but in fact the boundaries of that are kind of fuzzy. There's one area, which I'll talk about, where the boundaries are not at all fuzzy, where it's quite clearly established. But the idea that the First Amendment protects your ability to be where news is happening is actually a very unsettled proposition. So for example, student on your campus hears that the president of the university is going to have a meeting with the athletic director in the president's office, and they're going to talk about the possibility of firing the football coach. Big news story, you want to be there. Do you have a First Amendment entitlement to sit in on that meeting? Answer seems to be quite clearly no, you don't. You don't have a constitutional right to insist on sitting down in a chair in the president's office in an otherwise private meeting. You may have resort to a state open meetings statute, not the Constitution. You may have resort to a state open meetings statute, although in a case like that, I can tell you that just a meeting between two executives of an agency like a university, not covered by any state open meetings act, you're not going to get into that meeting, right? So the right to publish news is very well established. The right to be where news is happening, not nearly so much, not nearly so broad. And so you have to rely on either state open meeting statutes, or you have to rely on being planted in a place where you have a legally established right to plant your feet. In other words, not in the president's office, but the question is, and it's a clearer question, when your feet are planted on a sidewalk or a park, a piece of public property where you have an absolute right to stand. Then your rights are quite a bit clearer. Your right to gather news in a setting like that, let's say on a public sidewalk, seems to be quite broad, and there's not very much at all that the government can do to stop you. And this has happened from time to time. A photojournalist, I dealt with a situation a couple years ago down in Tampa, Florida. Some student videographers were just shooting some B-roll for a class. They had their tripod planted on a public sidewalk, not obstructing traffic, not doing anything legally impermissible, and people came out, security comes out from the city bus station and says, well, the bus station is a sensitive area because it's a transportation hub and might be a terrorist target, and so you can't take photos or videos of the exterior of our bus station. Well, the law is very clear there that there is no such thing as a private building exterior. The answer to that question is, if you didn't like your building being photographed, you shouldn't have put it facing a public street. So there's nothing at all that the police or security can do to stop you from standing in a place where it's legal to plant your feet and take photographs and take video. And in fact, if they were to cite you for trespassing or take your camera away or do anything to interfere with your news gathering, it seems pretty clear that they'd be violating the First Amendment. And in fact, photojournalists and videographers have successfully sued for damages in a case like that, where a government agency like a police department or a sheriff's department uses their arrest authority to impede somebody from shooting video or taking photos in a place where they have a right to plant their feet. Now, outside of the Constitution, the question arises quite a lot. What happens if I take a photo or I shoot a video and it's not the outside of a building, but it's a person, right? It's an individual who is sensitive about being photographed or being in my video. Do they have some kind of a privacy right to insist that I delete the footage or that I not publish the footage? And again, the answer to that seems pretty clear under the law. There is no such thing under US law as being private in public. There is no such thing under US law as being private in public. And so once you step outside of your front door and you expose yourself to being seen by strangers, you're in a place where you're at risk of being seen by people that you don't know, you're viewable to public foot traffic, you have waived what the law recognizes as the reasonable expectation of privacy. There is no longer a reasonable expectation of privacy when you go to a place that is open to public foot traffic. At that point, you lose any ability to bring a claim for invasion of privacy. So when that person comes up, let's use an example like the lobby of a Hilton hotel. Photographing, you're doing a news story that somehow involves tourism or travel, and you think, well, I'd like some B-roll of people walking through the lobby of the Hilton Hotel. God, remember when we used to do that? That was fun. I would just want some B-roll of people maybe enjoying a coffee, having their breakfast, reading the newspaper in this lobby of the Hilton Hotel. I'm going to take my television camera. There's no posted signs that say, don't take photos in here. I see other people doing it with their smartphones, and so it doesn't seem to be any reason that I can't take this photo. I'm not a trespasser here. But somebody's sensitive about it. They're eating their breakfast. They don't like showing up in my news footage. Can they stop me from using the footage? And the answer seems to be no, they don't have any legal right to insist on not being in your news footage. Why? Because they're sitting in a place where they're exposed to being seen by strangers. And notice that I'm being careful not to say public property. I'm saying place where you're exposed to being seen by strangers, because after all, the Hilton Hotel is not government property, right? It's not publicly owned property, but it is certainly publicly viewable property. It is certainly a place where you've put yourself on display to a certain extent, and you've waived any expectation of privacy. No claim for invasion of privacy, therefore it is your footage to use. Now, would you use it over somebody's strenuous objections? That's where your ethics and your professionalism and your good judgment comes in. Somebody has a compelling reason, right? Maybe they say, look, I'm a battered spouse and I'm on the run from my abusive husband, and the last thing I want is for him to know what hotel I'm staying at. Well, of course then, right, you would make the good ethical and professional judgment to say, one picture of a person in a hotel lobby is the same as the next for my B-roll. Of course I won't use this. This person has now given me a compelling reason ethically and professionally not to use it. But do I have a legal right to use it? Yeah, that's my footage. I can do what I want with it. And I should say, plain an asterisk on this, there is not a blanket exception for children. There is not, under US law, any such thing as a Minors Invisibility Act. This is widely misperceived by people. I think based on the fact that there are some areas of the law, like juvenile court, right? Or like education records maintained by a school, where there is a heightened privacy right for kids, but walking around in public is not one of those places. And so when a parent takes their child to the park and they're climbing on the monkey bars, if they happen to show up in your B-roll or they show up in your photograph, still your photograph to use. There is no children's invisibility law. This is one of those times, the law doesn't always perfectly align with your common sense, but this is one place where it really does. You know that that's got to be the law. You know that it cannot be the case that you're violating somebody's privacy just because their child shows up in your photo or your video, because then nobody could go to a ball game and take pictures. Nobody could go to Disneyland and take pictures. Oh, remember that? Remember going to amusement parks, going to ball games? That was fun. We should do that again sometime. Think of it as the Macy's Thanksgiving Day Parade rule, right? How could NBC television possibly televise the Macy's Thanksgiving Day Parade if there was a children's invisibility law? If every single time they got a child's face on the Macy's Thanksgiving Day Parade telecast, they had to have a lawyer run out to the side of the road and get a signed parental release, it would shut down, right? There'd be no way to have that telecast. And so we know that that's not the law. We know from our own experience that that's not the law. And again, would you make a good ethical and professional judgment if a parent comes running up and they're crying and they're screaming and they're saying, please don't photograph my child, I have some particularly compelling reason why they shouldn't be in your photo? Absolutely, right? That'd be good ethical and professional judgment, good kind of community relations, audience relations, not to use it. But is it your legal right to use it? Yeah, it absolutely is. That's about as much. Oh, so let's one more point on that, because I did mention, right, there's one area of First Amendment law where it does seem quite clear that the law is on your side constitutionally. And that is when you're photographing or taking audio or video recordings of law enforcement agents. So when it's not a parent and a child on the monkey bars, but when it's a cop who's making an arrest by the side of the road, the federal courts have been unanimous in saying that that is constitutionally protected news gathering activity. So we know that much for sure. While there is not a broadly established news gathering right that is nearly so broad as the First Amendment news publishing right, we do know for a fact that there is a right to take video, audio, and stills of the police doing police business in a place that is viewable to the public. If a police officer says, I don't want to be in your picture, hand over that camera, and they grab the camera away, or they delete the footage, or they order you to do so, they're violating the First Amendment. They may also, as a bonus, be violating, there's a federal statute called the Privacy Protection Act that protects the integrity of places where journalists store their unpublished work, so they also may be violating that federal statute, but they're most certainly violating the First Amendment. So we do know that for a fact. We do know that the Constitution protects the right to gather images of police doing police business in a viewable place. Why? Because the courts regard police activity as being kind of a uniquely sensitive activity that is of uniquely high importance to the public. We need to know what the police are up to. We need to know how they're using their arrest authority, how they're using force against the public, how they're taking away people's freedom. And for that reason, there is a kind of a heightened First Amendment interest that the courts unanimously have recognized. So you know you're solid there. That's the news gathering point. Now let's talk about the news publishing point, because what's going to happen from time to time is a student is going to come to you and is going to ask a question about, what can I use that isn't mine? When can I use a photo, a video, a song that somebody else posted to the web, and how can I incorporate that into my own journalistic work without violating the law? And this is one of the many reasons that people hate lawyers, but the answer is it's complicated. It is a very case-by-case, situation-by-situation judgment. So I'll leave you with some general principles about copyright law and encourage you to consult counsel if you have a specific judgment call you've got to make that's very sensitive. But as a general matter, as a starting point, you should always begin with the assumption that when you find something online that you didn't create, that it is protected by copyright, and that you're going to either need the consent of the person who created it in order to reuse it, or you're going to have to do your own work. You're going to have to take your own photograph, make your own drawing, shoot your own video, compose your own song, right? So start with the premise that everything I find online is somebody else's copyright protected property, and I'm going to either need consent or I'm going to have to find some kind of a workaround. We'll talk about the workarounds in a minute. Safest thing is always do your own. Right, safest is always to do your own, and it's the best journalistic practice, right? Dropping and dragging is not a marketable journalistic skill. Doing your own cartoon, taking your own photographs, yeah, that's a marketable journalistic skill. So always better to do your own if you can. But what if you can't? What if there's an irreplaceable thing that you've absolutely got to have? Then copyright law recognizes a doctrine called fair use. There is a workaround, there is a defense to copyright infringement that will allow certain people under certain situations to republish parts of other people's copyright protected work when it is kind of necessary for purposes of storytelling or criticism or commentary. And the good news is that journalists and educators and nonprofits get a little more fair use elbow room, this kind of a thumb on the scale for people who are doing it, not to resell somebody else's work for profit, but to incorporate it into another piece of creative work, especially where it fits one of those descriptions. I'm doing it for journalistic purposes or storytelling, commentary, criticism. Those things get a little extra recognition in that fair use equation. Right. So once we've established that you're using somebody else's copyright protected property, and let's just use photos because it often is photos. It's usually something like I want to do a presentation and I need to use this particular photograph to enhance my presentation, and it's not something I can take myself. So I'm going to have to borrow it from this online source. When is it safe for me to do that? One of the big kind of decision points there is, what is it that you are using this image for? What are you using it for? Because sometimes the very same image can be safe or unsafe depending on the purpose for which you are using it. I'll give you an example. So suppose somebody is doing a story on your college campus about the guy who's the quarterback on a football team, and that person happens to be on the cover of Sports Illustrated magazine. Right? And it's a wonderful photograph. It's a beautiful photograph. It's the kind of photograph that the reporter that you're working with can't duplicate themselves. You know, maybe they scored the winning touchdown in the Rose Bowl, right? And they weren't there. They can't go back and replicate the Rose Bowl touchdown photograph. So they say, well, look, I can't possibly do my own version of this. I gotta use this photograph from the cover of Sports Illustrated in order to tell my story. So here's an example where it wouldn't be recognized as a defensible fair use. If I'm just using that photograph as a substitute for having my own photograph of it, or for purchasing it, or creating some kind of workaround, right? So I'm doing a profile on that quarterback, and I just decide that, you know, that's the nicest photograph I can find online, and it would really dress up my story a lot to have it, so I'm gonna just drop it and drag it into my presentation. Well, now you're doing it, right, just as a substitute for having or taking or purchasing a photograph of that person yourself. Not going to be a highly recognized fair use, right? But suppose instead the story is about being on the cover of Sports Illustrated. The story is about the Sports Illustrated cover jinx, right? This fabled curse that afflicts your performance after you've appeared on the cover of Sports Illustrated magazine. At that point, it would be a slam dunk fair use. I think any lawyer would tell you that you can safely reproduce the cover of Sports Illustrated magazine in your presentation about the Sports Illustrated jinx. Why? Because I'm commenting on that exact piece of creative work, and only that exact piece of creative work can do, right? I can't very well go out and take my own photograph of the quarterback, you know, standing by his dorm room and say, well, this is somewhat similar to the Sports Illustrated cover. I gotta show the Sports Illustrated cover in order to document that he appeared on the cover, right? I need it for storytelling purposes, and I'm commenting on the cover. So that's a slam dunk fair use. I am commenting on the piece of artistry itself. I am commenting on the piece of creative work itself. This is what enables people like music critics or book reviewers to use excerpts out of people's work in order to comment on the work. So all of that is just fine. Where you get into trouble is when you're using and borrowing pieces of people's creative work that doesn't belong to you without consent, just to dress up a story or in lieu of purchasing a copy yourself. One of the worst cases of this I ever dealt with as a lawyer, I remember the nightmare of getting a call from a student publication that said, well, we wanted to do a story about the trend in our campus about using hair extensions, that women were using a lot of these hair extensions, and we just wanted to do kind of a fashion piece about the popularity of hair extensions. And one of our reporters just got sloppy on deadline and went on Google image search and got the first nice looking picture of hair extensions that he could and dropped it into our layout, and come to find out it's a piece of copyright protected property. And my answer was, well, you just bought yourself a $600 copyright lesson. You're going to have to pay the demand from the photograph owner, which turned out to be one of these stock photo type services. You're going to have to pay the demand because I can't help you. I can't defend that use of it as a fair use. You had the opportunity to take your own photograph of somebody on your campus with hair extensions, and you chose to get lazy and sloppy and just use this as a substitute. You weren't commenting on the hair extension photo, right? You weren't critiquing or reviewing this as a piece of photography. You were just using it as a substitute for taking your own. You lose, right? So don't do that. In particular, when someone tells you I'm using a photograph that I found online from another source, always be mindful of where that came from. Always be mindful of who is the original creator and owner of that work, because certain owners and creators are especially aggressive about defending their copyrights. Think about the kind of people who are most motivated to be copyright plaintiffs. That would be stock photo services and wire services. People like Associated Press, Reuters, Getty Image, Agence France-Presse. Anybody that sells photos for a living will be aggressive about defending their copyright because it is their livelihood. And if people just start making free duplicates of their photos without licensing them, without paying for them, they go out of business. So those are your most motivated copyright plaintiffs, and that is the least safe place from which to borrow. Is there any safe place from which to borrow? People will ask all the time. I'm under the impression, I'm under the belief that when somebody shares a photo on social media, that they've waived copyright ownership, that it's anything goes, open season, download the photograph and republish it at will. Get that out of your head. Not the law, never been the law. When you publish a photograph to a platform like Facebook or Instagram, what you're doing is you're licensing that photo to Facebook or to Instagram for the purposes of use within that app. And so Facebook owns a license in order to be able to redistribute your work so that other people can share it, can make duplicates of it within the platform and use it for purposes of the app. That doesn't mean that you've relinquished copyright ownership as the creator. It doesn't mean that you've waived the ability to bring an enforcement action if somebody uses it in an unauthorized way. Is it as unsafe as using an Associated Press wire photo? No, it's not, obviously, right? People don't generally have an economic motivation to pursue a copyright infringement claim for the reuse of a casual photo of their dog that was shared on social media. That's not their livelihood. They don't have any interest in hiring a lawyer and taking you to court. But could they? Yes, because copyright attaches to a piece of property at the moment that it is created. It is no longer the law, it hasn't been the law for many years, that you have to file it with the Copyright Office and attach a copyright C in a circle next to it, right? Hasn't been the law for many years. It is a copyright protected piece of property at the point at which you click the shutter. And so is it possible for somebody to bring a copyright infringement claim based on replicating work that you found on social media? It is absolutely possible to do that. And so keep in mind, again, am I using this piece of work because the piece of work itself is newsworthy, right? Maybe I'm doing a story about the fact that, let's go back to my football quarterback. Maybe he shares a photo on social media. This actually happened at a university a few years ago. He shares a photo on social media saying, I'm down on South Beach partying and drinking with a bunch of sports agents who bought me a free wristwatch. Well, now we're talking a newsworthy photograph, right? Now you can republish the fact that he shared that image on social media because his sharing the photo on social media is itself news, and you are commenting on the fact of his sharing the photo on social media. But if you're using the photograph as a lazy workaround for taking your own picture of the quarterback, no. Same copyright rules still apply, just don't do it, and certainly don't do it without obtaining consent. Last point on copyright, just to give you a little bit of reassurance so that you can sleep at night, is that as an educator, you get quite a lot of copyright leeway to reuse protected material inside of the classroom, inside of those four walls. Remember classrooms? That was fun. We should do that again. Inside of those four walls, you get to reuse those photographs, those videos, articles, right? The Sports Illustrated cover story is somehow pertinent to the curriculum that you're teaching. You are welcome to take Sports Illustrated magazine and put it on your Xerox machine and hand out 30 copies of that cover story to your students. You're not violating the law as long as it is for in-class use. When you get into problems, both legally and practically, is when the content jumps the walls of the classroom and goes online. when you take something that you use for classroom use and you post it to a platform like YouTube, then you are at greater risk. A, because more people can see it, and also because the copyright holder can see it. And copyright holders have become increasingly aggressive, particularly about patrolling platforms like YouTube and Vimeo. And so if you put a video on one of those platforms that has a copyright protected song or copyright protected footage from a television program or a movie, be prepared for it to be deactivated. Be prepared for it to be taken down. They have very aggressive bots that are trolling these websites for exactly that thing, and you will get caught. Will you get sued? Will you have to pay damages? Probably not, but will it get taken down and deactivated, and will that be a bummer? Yes. So I wanted to make sure to hit a little bit about gathering news, a little bit about publishing news, and I appreciate the opportunity to spend these few minutes with you. And I wish you a lot of luck in pursuing the study of teaching multimedia journalism. My email is flomante@ufl.edu. Website for the Brechner Center is just brechner.org, brechner.org. Always happy to hear from you, always happy to answer questions, and always recommend reaching out to Student Press Law Center, which is a wonderful free service. Thanks.